Okay, everybody. So I just got done with Lincoln Lawyer season 2, episode 1, and I want to tell you I absolutely love it. I love this show. I love episode 1. But while watching the show, the one thing that kept coming to my mind is I really need to talk to people and tell them how this compares to being a real criminal defense attorney because it's something I do know about. It's something I have seen and been a part of. Um, and I think there's parts of it that are actually very realistic. I've talked to other criminal defense attorneys in the last season 1. There were some very, very realistic things. Now, obviously, there's going to be spoilers when we talk about this. Obviously, it's about the first episode. I haven't seen the rest, so I don't know if I'm going to predict what happens in the future. I do know we're going to talk about big reveals that happened in episode 1, but I want to talk about it. Let's talk about it. And I really enjoyed it. So, number one, the big thing at the beginning of the episode will ruin the end for you later, but at the beginning of the episode, they keep talking about doing a retrial for the big case that he found the secret witness for at the last minute of the first season. He found the secret witness, and now they're talking about retrying it. Let's talk about how retrials work relatively quickly. Number one, retrials are miserable. And what I mean by that is no one ever, as attorneys, and especially as a defendant, want to do a retrial when a jury is hung or when a prior case is struck, as it was in this case. When a jury is hung, the prosecution has a right to retry the case. Now, if you're acquitted, if 12 people agree that you are not guilty of the charge, you cannot be retried. But if it's anything other than that, if it's a hung jury, meaning one person is on the other side, either only one person thinks you're guilty or one person thinks you're not, if it's not unanimous, then they do have a right to retrial. Now, in a retrial, both sides will usually, almost always, pay for the transcript from the original case. What that means is everything you've said before, you're bound to and you're held to. I should tell you about my prior retrial because I had one retrial that was very, very intense, and it was a very, very different outcome the second time around. And that's highly possible because you can hold people to a prior statement, and quite often, witnesses now have a little bit of practice. Maybe they never testified before, maybe they will testify now. Um, the worst part for a defense attorney, though, in retrial type of cases, if you kept your defendant from keeping a statement, if he never gave an original statement to the police, if he managed to avoid it that long, and then he testifies in court, the prosecutor now has a full transcript of your entire defense, and he's bound by that, and they can prepare that for their cross-examine later, look for new evidence that contradicts, excuse me, whatever he said previously. That's the main big problem with the retrial for the defense. So it is sort of miserable to go through it one more time. Now, as this particular case goes, the reason why, if my memory serves, as the season 1, why they had to release him is they found that the chief detective on the case, was the chief detective or the main police officer, was either manufacturing evidence or manufacturing witnesses, scaring witnesses away. Now, this is the issue. If evidence in the original case was either manufactured or manipulated for the original case, that evidence in the retrial either can't be used or is going to be used against the prosecution. So I'd find it very hard if they're going to retry the case using previous evidence. If any evidence was filtered through that detective, or there were other police officers who answered to that detective, meaning that their supervisor later either got arrested or got in trouble for lying to the police, filling out false police reports, most of that evidence is destroyed and can't come in later. So I don't know in this case that's realistic to say they'd be retrialed. That being said, subsequently he does give a statement to the new detective, Detective Griggs. So we'll talk about that in a second. Um, Let's talk about the TRO that's right in my wheelhouse. That's correct. If you have a TRO, which is a personal type of TRO, and he's correct, they really can't get a TRO unless there's some sort of threatening action. In my jurisdiction, every jurisdiction is slightly different, but it's either some sort of threat, you're a victim of a crime, or it's repeated contact not for a legitimate purpose, meaning someone continuously annoys you, harasses you. Maybe they don't commit a crime against you, but they won't leave you alone multiple repeated times, even though you've asked them to, and it's not for a legitimate purpose. You can't use that, for example, to stop somebody who you owe money and they're asking legitimately, can I get my money back? You can't just get a TRO. So in this case, very clearly, based on what little we've heard so far in episode 1, there's no grounds for a TRO. My assumption is, like many defendants, she may have not told the Lincoln lawyer in this case everything he needed to hear. So this is one of those things where I have a strong belief we are going to trickle in and see more information from her subsequently as far as what other types of accusations they're accusing her of. I'm going to go through this kind of quick, so I want to get to the big thing at the end. I do want to point out, the fact that his eyebrows didn't raise at the point he's now talked to her. He slept with her. She engineered to sleep with him immediately, and then within sort of 2 days, she already has 2 legal problems she brings to him. That his eyebrows didn't raise about that he didn't immediately go, okay, this is, if there's any type of red flag for a criminal defense attorney, it's that she needs your legal help within 3 hours of waking up, let's say, the next day. Not that I have any experience with that, but I would just strongly suggest that's what should happen. Now, depending on your jurisdiction, you should not be sleeping with your clients. That being said, if you have slept with someone first and they subsequently become your client, there's nowhere where that is against the rules of professional conduct, as far as I know. Okay. I'm right in the middle of this video, but let's take a minute to say hi to baby. Hey, Maxie, you want to say hi?
Hi.
Say hello, everybody.
Hi.
Okay, do you want to go to sleep with mommy, or you want to come hang out with me and make a video?
Video.
Okay, well, you sit right here, and then let's keep talking about this TV show. You didn't get to see the TV show, but we're going to talk about it anyway. I hope I don't ruin it for you. Okay. So, okay, here we go. All right, so then the scene where they go to see Griggs. Let me see if I can put Maxie on camera, because it might be better looking than me. Oh, there we go. So the scene where they go to see Griggs, as far as making a statement to the police. Number one, you would never do that without some kind of insurance that they're not going to use it against him in the future. As far as what we call a queen for a day letter is usually what we call it, where anything you say, they won't use it against you, even though you testify. Even though you make a statement in this. I need you to not make noise by the microphone. Even though you won't make a statement in this particular case, they're not going to use it against you. We call that a queen for a day letter. It's a classic phrase. It's another word for it. There's one thing he did say. He said, it was the dumbest mistake a defense attorney can make is he trusted a cop. That's absolutely true in a situation like this. You really need to use your experience. I will tell you, Griggs came in a lot harder and a lot hotter than any cop I've really seen in an actual situation. Normally, all that evidence that they have, at least what I've seen in these cases, is they don't really show it to you. They know they have it. They keep it in their back pocket. But the classic TV show of we're going to throw it down in front of you, and then look at this. We're going to do, especially when your attorney's sitting there. I haven't honestly really seen that happen. Now, where he says we're not going to continue the statement, it's done now, in your Fifth Amendment right, even if you waive your Fifth Amendment right and you agree to speak to the police, you still have it. You can invoke it at any time, at any point during a criminal investigation, at any point during a statement you're making to a police officer or detective. You can always say, I want to stop right now. I need an attorney, or I want to stop right now. I'm not going to continue making this statement. I'm not answering any more questions. And then you refuse and stop asking any more questions. You have that right to do it. And in this case, we saw the Lincoln lawyer actually exercise that right. But yeah, he needed more guarantees. For him to make it, you either need a guarantee in writing, or you need some other kind of guarantee, maybe a guarantee that it's completely off the record, meaning that nothing you say in that will be used either against him positively or negatively, so they can talk to him. But in that particular case, the case that we're talking about, what the defense was that there was a different eyewitness who saw somebody else. There's no need to have the defendant testify. He doesn't have any part of it. He doesn't know really what's going on. What you needed was that other person to come make Glory Days. You needed her to come make a statement. Let me talk about the last scene in court where he sort of works it out, the last deal. He shows up. He hasn't talked to the client that much. He has photos. He talks to the prosecutor, and they work out some kind of plea agreement in the very last minute. Like that's just some last minute thing that they figure out. There you go. Go see mommy. Get your train. Go see mommy. So when we talk about the way they worked out a plea agreement and sort of the last minute he shows up, says, now in a felony case they may not work like that. It's probably need more time to work out something like that, but that's exactly how it works in misdemeanor court. You show up, you say, hey, knock it down, here's my reasons, clean record, never been in trouble, easy to misunderstand. They say no, you say come on. They say, well, you say, all right, let's do it in trial. And they say, well, we don't want to do this in trial because it's a lot more work that we have to do. That part about a black guy on the prosecutor's office and the police department, I don't know how much that really holds weight. But the other parts of it, yeah, that's the way it is. And the fact that it's the last minute, he didn't talk to him that much. He sort of worked it out based on a very quick statement that he got from him in custody. I've seen that happen thousands of times. Like that is not, absolutely not rare at all. Okay, so now that I put the kids to sleep, let's go ahead and talk about the big reveal at the end that the person he represented at the last minute is the real killer who he was really looking for all through the first season and finally found. Now, what ends up triggering this is an ethics conundrum. Now, when we talk about legal ethics, that's what's most interesting about legal TV shows, because lawyers have to work with ethics that are different than the average person. We don't work with who do I believe more. We have to work with beyond a reasonable doubt, for example. Ethics is when you have to follow certain rules to make sure everything's fair. Functionally, lawyers, especially criminal defense attorneys, have to serve a higher purpose. Now, we can disagree if it's a higher purpose or not. But the theory is they have to serve a higher purpose. That purpose being that if you do not have a criminal defense lawyer to help you out, the system is at a level that the average person, even less than the average person, the person who has to work at a lower level mentally, won't be able to navigate and won't be able to understand. And for that reason, the system then would not be fair. So to keep the system fair to everybody, we provide everybody, it's the public defender system, as well as your own attorney if you so choose to pay for one. We provide everybody with the right to have an attorney to represent themselves in criminal court. You have to be able to trust your lawyer with anything you have, and know that there's only two times when a lawyer is allowed to break confidentiality. Number one is when a lawyer, when you tell the lawyer you're going to commit a crime. So we saw that here with the threat. Now, let me talk to you more about that. But number one is when they're going to commit a crime. Number two is when they accuse you of doing something wrong. So you can't accuse me as your lawyer of cheating you or hurting you or hiding something. And then I have to say, well, I'm not allowed to tell you what happened because there's confidentiality. Because that would be unfair. Actually, it would end up being unfair to you, not unfair to me. People would believe me. I'm the lawyer. It would be unfair to you if I was able to hide behind that. So for that reason, those are the two situations where confidentiality is washed away. One, to stop an impending crime. And I think there might be in certain jurisdictions restrictions on what type of crime. For example, just because you're going to jaywalk or just because you're going to trespass doesn't mean I'm allowed to say that. But if someone's actually going to get hurt, absolutely, I may be actually required to tell if I believe that's what's going to happen. Now, in this situation, I believe very clearly that was a threat. I know where your family is. I know where your kids are. I'm not going to do anything to them. I don't know why you think I would. Remember, the important thing is not what they say, it's what they mean. And if it's very clear to you that what they mean is ill will, if they're going to commit a crime, not just ill will, excuse me, but if they're going to commit a crime threatening you or your family, even if the words say they're not going to, if very clearly from what they say or what they do, their intentions are they're going to, then absolutely that could break confidentiality. You have a right to break confidentiality there. As yet, there's nothing where he's making a complaint about them or accusing him of doing something wrong, so there's nothing there. Now, in the situation like this, what should happen? Number one, The Lincoln lawyer should have immediately told him when he said, I paid you more money because I have something to tell you. One, he should have told him those two exceptions. He didn't say that at all, and he should have. Number two, he probably should have said, no, 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 I'm not accepting your money. I'm immediately going to return it. I do not represent you anymore. Something's fishy about that. If that doesn't, as a lawyer, when someone says, I need to know that I can tell you anything, if that doesn't raise about something when you know they don't have a case pending, if that doesn't raise your hackles that there's something criminal going on, that you're about to get in trouble, you need to sort of think about that, know that. Now, there's ways to get around that. You stop them from telling you. You speak over them so you cannot hear them, so you don't. But then what you're able to do is ask them questions around the question. What are you talking to me about? Is this going to be about a potential crime in the future? Are you telling me about a confession to something you've done in the past? Because then you would put a price on it. You don't get to just give me an arbitrary amount of money, in this case $5,000, and they think that buys my silence forever. That's not the way the system works. Now, unfortunately, in this case, I think the Lincoln lawyer had too much on his plate, at least story-wise, had too much on his plate, and that's what he went for. Now, if the person has reasonable belief that they have attorney-client relationship with you, that you are bound by attorney-client. That's my understanding of the way I was taught the ethics rules, and I'm okay to be told I'm wrong. Please tell me if I am. But if they have reasonable belief, you have to be bound by that. Meaning, the man with the kanji tattoo, he went through the steps to make sure there was arguable, reasonable belief. And even if there's not a signed contract based on the conversation, based on the previous discussion, based on the fact that they took his money and they said it was retainer for cases going forward and it seemed to be accepted, all these things seem to think that there would be a reasonable expectation of attorney-client relationship. In that case, you have to be bound by the attorney-client relationship, even if you subsequently were to say, no, 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 that was a misunderstanding. I'm not representing you. Now, had he stopped him before he said anything, had he said, there is no attorney-client relationship, I am returning all your money, do not tell me anything, and then the person continues to talk, I believe that would be more defensible as far as explaining what's going on, giving it up, or passing that out to someone else. He'd still want to talk to your malpractice carrier, your insurance first, but I think that's the way it would go. What's going to happen in this situation if this was real life? Oh, let me tell you this. When I was a young public defender, I had a client actually give me an eyewitness phone number. I called that eyewitness, and when I called the eyewitness, we started talking about the case, and they were getting confused. And they said, Marcus, what are you talking about? And I said, what do you mean? They're like, they were talking about a different case. And it turned out they were also my client. I knew them by their government name because that's what was in the police reports. That's what I discussed them with, and we had spoken previously. I didn't put the two phone numbers together. The name that was given me as the witness was, let me say their street name, but it was their nickname. And so when I spoke to them, what ended up happening is I got the story from them, but I can't represent two people who are witnesses in the same case. I can't have a witness who I represent in an unrelated case, but that also represent the person in this case. That's not fair to anybody. It's not fair to them. It's not fair to the justice system, so I just can't do that. I was required to withdraw from the witness's case in that situation. We were able to continue with the one client and able to keep that client. And someone else had to represent the person who was the witness in that case, which was too bad because she was a very nice girl. I really liked her, actually. Could that happen here? Now that he has this information, the only thing he can probably do is withdraw from both cases ethically. He cannot tell. What he has to do is find another attorney who's willing to investigate. Either he finds or he refers, and make sure that attorney represents the client who's on arrest time to the best of their ability. Now, obviously, that's not what they want. It's probably not what he wants. But now that he has a client who he has an attorney-client relationship, made a confession to him, which is to the detriment of his other client, representing them both would be a detriment to either one, he probably has to withdraw from one. Now, he's going to want to withdraw from the other guy, which there's no pending case. I would honestly just give him 100% of his money back And I would probably give him the money back for the previous case just to say, I want to make sure there's no question about this. That there with a strong letter that says, I do not represent you, I will not represent you in anything going forward. But at the same time, I don't believe he can continue to represent the prior case. And if he tries to continue to represent his previous client in spite of having this new information, I think that's a strong ethical lapse, and I don't think he should be able to do it. But I'm still very interested to find out how they handle it in the second episode. So tell me if you like this, if you want to see more of these, if this is something, let me see, if this is something I can do, maybe you guys like, is something slightly different from Tory Lanez as far as the Lincoln Lawyer goes. I would love to do more of these. If you like them, tell me and I'll do more. And if not, I might just do them anyway. And we'll see what's going on. But hopefully the man with the kanji tattoo gets what's coming to him. Thank you guys very much, and I always appreciate your time.